and 2 are circulated in my name together.
Is leave granted? Leave is granted. The member for Wentworth.
I move amendments 1 and 2 are circulated in my name together. Deputy Speaker.
The question is that the amendments be agreed to. The member for Wentworth has the call.
Deputy Speaker, I appreciate that we need to create a system that enables decisions to be made efficiently and fairly. And I believe that, I think I acknowledge the government's point that the Nixon review found that the system of review currently in the ART was being exploited to those by some to draw out and extend processes again, and particularly they highlighted student visas. And they recognised that with student visas now accounting for 40% of all lodgements, this can potentially have the impact of holding genuine reviews that are needed in limbo for months, often at great distress. So I acknowledge I do find there are good grounds for finding efficiencies within the ART system, such as increasing the scope to review cases on the papers. However, I do have concerns currently in how this legislation is drafted, and that is where it goes to the heart of my amendment. Because there are obvious concerns about mandating that a type of visa class must be decided purely on the papers. As the Law Council of Australia argues, the blanket refusal of oral hearings for all cases represents a disproportionate response to the issue at hand. And that brings me to my amendment. The legislation is currently drafted includes student visas, but also allows, within regulations, other visas to be captured by this blanket refusal of oral hearings. And I think this is of real concern, because there may be, there can be a case argued that student visas can be determined on the papers. Though there are some, I'll be honest, who argue that that is really not the case, particularly seeing that 50% of all study visa cancellations or refusals have been overturned, says that this is actually an area of great contention. But the fact that other visas could be included on this could also be problematic. And I go back to the Law Council of Australia, who said, while they support the government's decision to exclude protection visas, argues that it is likely that vulnerable applications could be captured by expanding these powers to other classes, including provisional partner visas, bridging visas and employer-sponsored visas. All of these things could be captured without coming back to the House. And to quote from the Law Council's submission to this bill, "These decisions go to the core of how the Tribunal operates for potentially wide groups of people and relate to its overall design as determined by Parliament only a year ago. Such decisions should not be left to delegated legislation." Now, while I acknowledge that these regulations are disallowable for something so fundamental to the role of the ART, I would agree again with the Law Council, who argues that, and I quote, "Decisions that remove the ability of whole classes of individuals to have a hearing should, if included in legislation at all, be determined by Parliament under primary legislation." And so, for these reasons and for those arguments as argued by the Law Council, that has driven me to draft this amendment, which would remove the minister's ability to expand this requirement to other temporary visa classes, instead needing further changes to be made in primary legislation as recommended by the Law Council. And I think we should just take a moment to reflect on what is the purpose of the ART and why this is important. The ART is the final place that individuals, where they feel that the state has not been fair or accurate in their dealings with them, it's the final place that individuals can make a case, and the state has to come up and be honest and adjudicate this fairly to make sure that the state has not overreached or that the state has not made a mistake in these places. This is up for citizens of our community just taking those actions. And my concern really with what this legislation in relation to the ART is that you're saying this legislation now says to people that they will only be determined on the papers, and this isn't the case. This is given the vulnerable Australians who may be making those representations to the ART, may be representing themselves, as I know many from my constituency have gone to the ART representing themselves, that they may have no opportunity to be heard in this current legislation, and this could be extended to other visa requirements, other visa classes, is of real concern. So I argue really that the government in this case should listen to the Law Council, should listen to the protections that the Law Council is arguing for, and should support my amendment in this case.
The question is that the amendments be agreed to. The Attorney-General has the call.
Thank you, Deputy Speaker. I thank the member for her contribution. The government will not be supporting this amendment. The government considers the regulation-making power necessary to ensure that the government can support the Administrative Review Tribunal appropriately respond to changes in its caseload in a more flexible way. As a regulation, it would of course be subject to disallowance by the Parliament as is appropriate. Importantly, the ability to apply the on-the-papers process to other visa types could only apply to reviewable migration decisions, expressly excluding protection visa matters in recognition that these are generally more complex.
The question is that the amendments be agreed to. The member for Wentworth.
Deputy Speaker, I'd like to ask the Minister about the sort of case that I'm trying to make in relation to vulnerable Australians who go to the ART to be heard on issues outside of student visas, and the fact that the government is has given itself the ability to grant it, to do it via regulation to exclude entire classes, to include other groups of applicants who would no longer be able to ever be heard in front of the ART themselves, and consider whether, particularly given the breadth of vulnerability of some of those people who might be included in that, why the government feels that it is appropriate to do this from a regulatory point of view as opposed to from a point of view of coming back to this Parliament and making the case. And I would love the Minister to engage on the question of why the government even drafted and determined the ART in its current form if it wanted, if it's willing to so quickly go back and say, okay, this should be, people should no longer have a hearing, and we give ourselves, the government, the opportunity to pass regulations on that basis, that whole groups of people should no longer have the opportunity to have a hearing. No longer when the ART professionals looking on the merits of the case say, I have additional questions here, these are important questions, I would like to be able to put them to the applicant, but under the legislation I will no longer, this is not going to be possible. And I just really want to understand which vulnerable groups the government has considered, because the acknowledgement that you've excluded temporary protection visas, I think, goes to the point that the government recognises there are some people who should not be able to be heard, who should not be able to be only considered on the papers. But really my question is, what about those other vulnerable people in those other classes? Why should they not be able to be determined on, to have the opportunity to be at least considered, including for a verbal hearing, as well as rather being excluded on the papers simply through regulation?